I also rise in opposition to SB 53, and I appreciate the enthusiasm and energy from our colleague from Palmdale Lancaster in also expressing his opposition to this bill, and I'll address that a little bit later in my notes. SB 53 is nothing more than an attempt to circumvent a recent court ruling on a similar bill. In Parker versus California, the Superior Court found the bill in question unconstitutional, and that ruling was upheld by the Court of Appeals. This case is still pending before the California Supreme Court. The courts have spoken, and the governor has too, stating that no additional ammunition registration bills should be enacted prior to the resolution of Parker versus California. But beyond the Parker case, California's policies to restrict law-abiding people from obtaining permits to carry firearms in Pruetta versus San Diego was also ruled unconstitutional. And just Monday, in Sylvester versus Harris, our 10-day waiting period was ruled unconstitutional as applied to persons who already own firearms. Members, we must take note of the fact that we've gone way too far in our attempt to solve crime by placing restrictions on those who already obey the law. There are numerous examples of courts striking overreaching gun laws enacted by other state legislatures and by municipalities here in California and throughout the U.S., which include San Francisco, Yolo, Chicago, Washington, D.C., Idaho, New York, Colorado, Nevada, Georgia, Florida, and many more, all unconstitutional. All these cases demonstrate the problems with doing an end run around what is constitutional, that being the Second Amendment. Let's be real, members. Putting a fee on a business, as this bill does, and then registering every ammo purchase will have no bearing on crime. And it's dead wrong for funding to come from the Firearms Safety and Enforcement Special Fund because there's absolutely no nexus between the fund and the expenditure. Why don't we switch it up and put barriers in the path of those who are intent on breaking the law, on those who are intent on causing harm? Madam Speaker, may I have permission to use a prop, please?
May I see what their prop is first?
It's a photo. It's a photo. Enlarged photo, Madam Speaker.
Without objection.
Thank you. To our members' point from Palmdale Lancaster, 33,000 emails stacked up on my desk that I was going to attempt to bring to the floor, but I thought it would be unwieldy for the sergeants to get it here. So 33,000 emails to my inbox in my district office, and most of your district offices have these same exact 33,000 emails. Did your district staff alert you to the outcry from Californians against this bill? 33,000 emails. Madam Speaker, may I have permission to read a short passage, please?
Without objection.
Thank you. From the U.S. Constitution, the Second Amendment, proposed September 15, 1789, and ratified December 15, 1791. A well-regulated militia, being necessary to the security of a free state, the right of the people, that's you and me and our constituents, to keep and bear arms shall not be infringed. Ladies and gentlemen of the California State Assembly, this bill violates the Second Amendment of the U.S. Constitution. And you know what? I know there are members on this floor that misunderstand the Second Amendment. And I know there are members on this floor that hate the Second Amendment. And you know what? That's okay.
30 seconds.
You can misunderstand it and you can hate it, because that's your First Amendment right. Under the U.S. Constitution given to us by our founders, you can hate the Second Amendment. But what you cannot do, what you do not have the authority to do, is infringe it. You do not have the authority, because you hate the Second Amendment, to take it away from me, or to take it away from my constituents, or to take it away from any Californian today. Ladies and gentlemen, of the Assembly
conclusion.
of the State of California, I humbly ask that you vote no on this bill today. Thank you.